Here is a courtroom scoreboard you were not meant to see. As of yesterday, the Justice Department has gone to federal court 20 times, demanding that states hand over their unredacted voter rolls. 20 times, it has lost. And on the 20th, a judge in Denver did not just deny the request, he dismissed the case with prejudice, which is a court's way of saying, do not come back. That is not a losing streak anymore. That is a verdict on the whole theory. So the question tonight is not whether the department is winning, it is why, after 20 straight defeats, it is opening new fronts instead of standing down. And the timing is not an accident, so let me put the calendar on the board. There is a provision in federal law, the National Voter Registration Act, that creates what is called a quiet period. Within 90 days of a federal election, states are barred from running systematic purges of their voter rolls. That window opened this week, 90 days out from the November 3rd election. So the department is pressing hardest for this voter data at the very moment the law is trying to freeze the rolls in place, losing in court and racing the calendar at the same time. Now here is the moment that gives the whole thing away, and it happened in a Washington state courtroom. A department lawyer, Raymond Yang, was asked by Judge Kimberly Evanson whether there was any real reason to treat Washington's case differently from all the cases the government had already lost. "No, Your Honor," he answered, and then the tell, in his very next breath, "Relevant facts are similar to all the other cases." The government's own attorney told a federal judge that this case is no different from the 20 it already lost. And the judge answered with the count herself. "By my count, this is the 20th court to address this exact issue." So what is the department fighting 20 courts to obtain? Your data. The unredacted voter rolls include driver's license numbers and social security numbers, the kind of information states are legally required to protect. Washington's Secretary of State, Steve Hobbs, put the objection plainly. The lawsuits, he said, seek private voter information that is protected under state law. And the department's stance is remarkable. It insists it needs those social security numbers, while also arguing it does not have to name a single factual reason to suspect any state broke a single law. Give us everything. We will not say why. And this is the part that matters, because losing has not slowed the department down. It has multiplied the fronts. On the very same day it lost Colorado, a watchdog group, Democracy Forward, sued the government for hiding records on how it is using federal immigration databases, including a system called SAVE inside election administration. So, follow the pattern. The front door lawsuits for the voter rolls are losing 20-0. So a new door opens, more quietly, to run voter data against immigration lists instead. When you cannot get the rolls through the front, you build a side entrance. And there is a third front, which this desk prosecuted just yesterday, the department's emergency request at the Supreme Court, Docket 26A124, to switch on its mail voting order before November. In that brief, to justify the whole program, the government leaned on a registration glitch in New Jersey, claiming at least 400 non-citizens had voted. Except local officials say fewer than 400 of the affected voters cast a ballot at all, and the reporting is blunt that the department greatly overstated it. Same department, same week, losing on the rolls, overstating in New Jersey, and asking the highest court to trust it anyway. So here is the verdict, and it is not close. 20 federal courts have looked at the same demand and said no, one of them with prejudice, and the department's own lawyer admitted there is nothing to distinguish the next one. A theory that loses 20 times is not a theory a court is going to rescue. But watch what a losing party does when it will not accept the loss. It does not stop. It spreads. New suits, new databases, a new brief at the Supreme Court built on a number it inflated. The scoreboard says the department has lost. The calendar says it is not done trying. Watch the new doors, not the old lawsuits. I'm Madeline, and this is Pixel Politics.